Okay, hopefully everybody can hear me. Thank you for coming. It's an interesting topic, certainly from the point of view of Brad and I, this sentencing and mental health. And as the lecture was billed, we were seeking to try to deliver to you this evening a summary, really, because it can only ever be a summary. There's so much material, but of the new guideline, and trying to think about how, as advocates, we can make the best use of that. But from the point of view of forensic mental health practitioners, how they can also best assist us to try and help those that do have particular needs to get the best out of the sentencing process. My name is Spenwyn, as many of you know. I'm a barrister at Libertas Chambers, and I've been practicing in crime now for 20 years. There's a real focus in my practice on cases that involve mental health issues. And of late, in particular, I've been working a great deal with Dr. Bradley Hillier, who's with us this evening, and I'm very grateful to him. We've worked on a number of cases together, a number of murder cases involving both issues of diminished responsibility and not, historic sex offence cases, cases involving arson, the whole range really, because of course mental health features in many cases, and I'm talking about the more serious end of the spectrum, but of course it features in most of the cases that we will all as practitioners deal with. Certainly from my point of view, dealing with Brad so far as an expert witness, what particularly is impressive to me as a practitioner, and I know the solicitors that I work with that also have used him, is that he has a very good manner with the client, which is perhaps the most important thing when you're seeking to gain the trust of somebody who has mental health difficulties. And there's a real skill, of course, that I'm sure he's honed over many years, but in him making sure that he really does get the best out of the client and is able to provide, therefore, the most useful report, not only for us, but perhaps more importantly for the court. He has a very extensive practice in terms of both clinical and forensic practice, and he's given expert evidence and of course reports in a number of cases. So he's really in a great position to give you some really useful help this evening. I'm just very briefly at the outset going to just run through some of the principles that are set out in the new guideline. I'm not going to teach any of you how to suck eggs and take you through the specific details, really just very much an overview to give a framework for what Brad, who you'll be much more interested in hearing from than from me, is going to help us with this evening. On the first slide that I've got there, I appreciate there's a lot of detail on these slides. It's not so much for the content because, of course, we will summarise them. But just at the outset, I just wanted to say something about the new sentencing code, as most of you will know, brought in by the Sentencing Act that came into force at the beginning of December. And whilst there's nothing new as such in the sentencing code, what it does is really bring everything together. And from the point of view of focusing on what we are this evening, the interplay between sentencing guidelines, sentencing law, and reports and other expert input, the sentencing code gives us really a framework for that, which I think is always useful to go back to sometimes, back to basics a little bit. And in section 59, it codifies the provision that was already there, but in relation to setting out that where offender is or appears to be suffering from a mental disorder, before passing a custodial sentence, the court must, and it is a must, order and consider a medical report, of course with the usual caveat, but the must there is quite significant. And also the provision there in subsection 2 that before passing sentence, the court must consider information that is before it in relation to an offender's mental condition, be it in a medical report, pre-sentence report, or otherwise. That section of the code then, of course, gives us the ability to go to the Sentencing Council guideline. And the link to that is the general duty of the court to refer to the guidelines. And really, again, it's a back to basics approach, but it just affirms the importance of the guidelines. And I think sometimes it's also worth reminding a judge of that, although certainly they should be very slow to dismiss any suggestion that the new guideline on mental health that shouldn't apply or isn't relevant. The guideline itself, it's very detailed, but when you go through it, there's a lot of just very useful aspects to it. And I've just pulled together a few of those just for the purposes again of the slide to give that overview. The guideline applies when sentencing anyone from the 1st of October, so any case that we deal with from now on. And it applies when sentencing somebody who at the time of the offence and or importantly at the time of sentencing may have a mental disorder, a neurological impairment or developmental disorder. And the guidelines should always be considered by the court, but again, one of those old caveats, may not necessarily have an impact on sentencing. Key paragraphs, just to draw your attention to, are 9 to 12. That sets out culpability. Those of you who are practitioners will know very well how to use culpability in any of the sentencing guidelines, but it's quite important. You will all know that a lot of the offence-specific guidelines have suffering from a mental disorder at the time as one of the factors to consider in mitigation. But this really gives a sort of an uplift to that. It gives a little bit more to it. And it's really important, I think, to have a look at those paragraphs when you're dealing with a case that may have this aspect to it. Also, paragraph 15 is important. And as it says there, the courts may find that there's a series of questions that are a useful starting point, really a bit of a checklist. And I would commend that also to you. Because it's a way of getting a judge to focus, to go through the checklist and to start thinking about it. And of course, as soon as you start doing that, in itself, it makes it real, it makes it come alive. The fact that this isn't just another piece of mitigation, it's not just another thing that's trotted out. It really is something that's important and needs to be considered. I think in particular, the insight reference is quite important there. And again, I'd suggest that in due course, when using the guideline, you have a look at that. I'm now going to stop talking, having given that rough framework of the overview of the guideline and what it's there for, and hand over to Brad, who's going to help us with a little bit more information as to specific areas of mental health that might be particularly relevant in the way that we deal with them in court, and then a few more practical tips, and then I'll come back to you shortly towards the end.
Thanks, Marie. Hi there, everybody. My name is Brad Hillier. I'm a consultant forensic psychiatrist. I currently work between two trusts. I work for West London Mental Health Trust, covering community forensic psychiatry in Kensington, Chelsea and Westminster. And I also work in the Addictions Mental Health Service in HMP Wandsworth. Thank you for inviting me to join you tonight. I thought what would be helpful perhaps is to, I think that the majority of the audience is a legal audience, although I'm aware that there are some people from the medical and clinical world here, but I thought it would be helpful to give a little bit of background to how we use ideas of mental disorder and different types of mental disorder, their prevalence, how they associate with offending and what the medical legal implications of that might be, particularly when thinking about how it might relate to disposal and sentencing issues. I just wanted to, before I talk about some of the definitions initially, I thought that I would just mention something called the Bradley Report. I suspect practitioners are aware of the Bradley Report, and certainly in forensic mental health. The Bradley Report, which was written or published in 2009, was a very significant landmark report, really, which looked at the criminal justice system and how people with mental disorder interface with it. And it made many, many recommendations. I think around 100 recommendations at the time that were taken into account in terms of really improving understanding and knowledge with the interface at various different stages and levels of the criminal justice system, with a view to consideration of diversion of people with mental disorders from the criminal justice system into the mental health system, if appropriate, not always and not without exception. But the idea, I think, was to raise the profile of mental health problems in offending behaviour and to start to set up systems within the criminal justice process to take account of that. And what we have seen is development of police liaison diversion practitioners in courts, and some standards around transferring prisoners with mental disorder, either remand prisoners or sentenced prisoners, to secure psychiatric settings. So that's, I think that the Sentencing Council guidelines could be seen in that context of a broader process over the last decade or so of mental disorder being taken into account in interfaces with the criminal justice system, and looking at alternatives to punishment, so treatment and taking mental disorder into account through sentencing options. But when we talk about mental disorder, and I'm going back to my slides now, where we in clinical terms, we're considering mental disorders which are understood within the Mental Health Act. Pre-2007, when the Act was amended, there were four categories which were considered, which was mental illness, severe mental illness, mental impairment, severe mental impairment, and psychopathic disorder. Now, in the 2007 amendments, this was abolished with a favour of the term mental disorder for a variety of reasons, but that's the terminology that needs to be satisfied. And mental disorder is broadly captured by the diagnoses that are within the International Classification of Diseases. The 10th edition is the current edition, and that's published by the World Health Organization. The Diagnostic Statistical Manual, 5th edition, the DSM-5, is also referred to as one of the manuals of mental disorders that is used. That's primarily US focus, but is increasingly used and is accepted to some degree in the courts. I think there are diagnoses in there which aren't shared, including culturally, really, with the UK psychiatric system. But the ICD-10 is the version which we tend to use in the UK in clinical practice, and hence apply to medical legal circumstances as well. In the sentencing guidelines that have been produced, actually, Annex A provides a list and quite a nice overview, really, of a variety of mental disorders, which are usually the ones of relevance in criminal justice circumstances. This was actually created with consultation from Professor Pamela Taylor, who was the chair of the forensic faculty at the Royal College of Psychiatrists until very recently, a professor at Cardiff University. So she was involved in and the forensic faculty were involved in the development of these guidelines. So what I will move on to now is my next slide. Thanks, Marie. There's a variety of different mental disorders which are in that annex, which are sometimes seen in criminal proceedings. I've listed them here. I'm happy for people to have copies of the slides. But these are the different categories of mental disorder. We have the psychotic illnesses. These are illnesses, mental illnesses, which include things like schizophrenia. People who have episodes of psychosis, which may not be because of schizophrenia, could include substance use, and also mood disorders as well, which sometimes can present with psychotic symptoms. I'll talk in a moment about what psychosis means. And then we have mood disorders, which may include things like bipolar disorder. It's also known as manic depression. And then the non-psychotic illnesses, PTSD, all of the illnesses beneath PTSD is commonly seen commonly raised in courts, in my experience. The developmental disorders, so these are disorders of development which include things like learning disabilities, things that emerge in childhood and tend to remain throughout life. Autism and Asperger's syndrome, so disorders of social interaction and behavior. And the dementia, so Alzheimer's disease, dementias which can be secondary to brain injuries, which may sit in between dementia and brain injury as a cognitive disorders, which lead to people's ability to process information being abnormal in some way. And I've mentioned pseudo-dementia, which is a presentation where people can seem as though they have dementia, but it can be due to other illnesses, other mental illnesses. Brain injury and brain disorders, so neurological disorders which may have a more physical basis, such as tumours, epilepsy, brain injuries because of accidents, and also brain injuries which may be as a consequence of substance misuse, as well as things like malignancies. And what is often really quite common, I think, in the populations which we deal with in both the criminal justice systems and in mental health within prisons and the forensic population, is people who have not just one of these, but multiple comorbidities, lots of diagnoses, often substance misuse and a mental illness. And the relationship between these is quite complex. Ideas that some of the use of substances is the person trying to self-medicate their symptoms, and questions about how much a substance can contribute to the emergence of an illness in vulnerable people. One thing that I've just noticed isn't on the slide, but is on my later slides, is personality disorder. Now, this is quite a complex and not uncontentious concept, which includes the idea that people's personalities cause them to have problems with the world and the way that they cope with stressors. But I'll talk about that in further slides. So if you want to go to the next slide, please, Marie. Next, oh, sorry. Thank you. So first of all, psychosis. Psychosis is a term that describes people who are experiencing perceptions, thoughts, so hallucinations, delusions, these ideas that things are happening that there's no evidence for in the real world. So they're disconnected from the real world, from the real experience, or they're taking in information from the real world and in some way understanding it in a very distorted or bizarre way. And so the illnesses and disorders that do this most commonly are things such as schizophrenia. Schizophrenia is about 1% of the population may have schizophrenia, although people who experience these episodes of psychosis can be up to 3% of the population. And there is an increased representation of people who have experienced psychosis in prison populations. Sometimes it can be the case that only in the context of offending, the first episode of psychosis emerges. There is association between psychosis and offending behavior, and there's quite a high association with psychosis and comorbid substance use. Up to about 30% of people who have psychosis can use substances either to self-medicate in some sort of way, or there's an association between the use of the substance and precipitating a psychosis, or the acute intoxication effects of the substance leading to a psychosis. So we have schizophrenia as the sort of the paradigm of a psychotic illness, but other types of illness, mental disorder can be associated with psychosis. So for example, in mood disorders, if they're very extreme or very severe, you can get psychotic features. Usually when we talk about psychosis, we're talking about things like delusions, so persecutory beliefs that somebody or something is being done to somebody or acting against them, but also other types of delusional beliefs such as grandiosity, people thinking that they might have special powers. People may have referential delusional beliefs, so they may talk about seeing certain things happening and realizing something relates to them, such as seeing a flashing, an indicator on a car, or a certain car going past their house frequently has a particular meaning to them. And usually when we talk about psychosis clinically, we're talking about the acute episodes where these symptoms are prominent. You could also get experiences in psychosis where people's thoughts feel interfered with by an outside entity. They experience their thoughts either being inserted or interfered with, or their thoughts being read out in their mind, for example. And sometimes when you speak to people who have these so-called thought disorder problems, they're unable to communicate properly because their thoughts aren't coherent. They're not making any sense. And that's a sort of a recognized psychotic symptom. Some of these disorders are lifelong, such as schizophrenia. There's no cure, and we use antipsychotics and psychological treatments and social adaptations to treat people. And some of them are amenable to treatment and can be a consequence of, say, a mood disorder, where once you've treated the underlying mood problem, you can get rid of psychosis. So I've talked a little bit about the delusions, and also the hallucinations are also a cardinal feature of some of the psychotic illnesses, often auditory hallucinations, people being commanded to do things, or a narrative of what they're doing, going on that they can hear all the time, or people talking about them in the third person, which are obviously quite unpleasant experiences and quite distressing. So it's not, you know, it's not surprising that if somebody is experiencing these kinds of symptoms all the time, that it significantly affects their behaviour and their thinking. Now, sometimes people are able to hold it together. They don't obviously talk about their symptoms, or they don't obviously demonstrate their symptoms, particularly not if you only see them for a short time. So usually when we do a psychiatric assessment, it's usually about an hour or more, usually at least an hour. And over that course of time, and certainly when people come to hospital, they're observed to see if their symptoms emerge. And it's usually with a period of observation that it's able to be possible to observe people responding to their voices or responding to their beliefs and their behavior. So talking to themselves or looking around and seeing that they're responding to absent external stimuli. And I think what's important is, despite the association between people with psychosis and violence and offending behavior, there's also a high likelihood of them being victims, much more so than people who don't have mental disorders. I've talked about first episodes of psychosis being a herald, and that being a circumstance where people can come into contact with the criminal justice system. And I can certainly think of quite serious cases where quite significant offences and chaotic offences have occurred when somebody is psychotic for the first time with no contact with services, and it becomes known in the criminal justice system. And I can think of a case I was involved in Leicester, where a young student developed a psychotic episode, which was in fact the first episode of a schizophrenic illness, and believed that his girlfriend was casting spells on him and was having hallucinations of spells, and became very distressed and fled the building he was in, and tried to believe that he was being pursued, and ultimately took a car, got into a car and went to a garage where the police were called, and he was extremely distressed and disoriented. And this wasn't really picked up in the prison, actually. So I was instructed to see this man as an expert, and it hadn't been picked up by the prison psychiatrist, who had noted some degree of grandiose thoughts. I think actually when I saw him, the man thought that he was Jesus. But you know, you have to have time, and you have to have the ability to spend some time. And sometimes that's where experts can do that, whereas the prison services aren't necessarily able to. I think in this man's outcome, he actually ended up being transferred to hospital, where he was whilst the trial went ahead, and he got a mental health disposal. So I think that gives a sense of the medical legal implications of psychosis. Obviously, if somebody is acutely unwell, they may not be fit to plead on a number of the limbs of Pritchard. There's the insanity defence, which may become important, and in homicides, diminished responsibilities. And in terms of mental health disposals, in many respects, psychosis can be regarded as a bit of a paradigm of how the mental health disposal process can work, the nature and the degree of a mental disorder. And in fact, the psychiatric hospitals, which have forensic patients, tend to have a lot of people who have psychotic illnesses, having contributed to their offending behaviour. Okay, would you like to go to the next slide, Marie? So looking at some other disorders, so mood disorders, similarly, these are the disorders of mood commonly associated with offending are bipolar disorder, and another one called schizoaffective disorder, which is a little bit of a cross in a way between a psychotic illness and a mood disorder. And people who have these episodes of mania, which may be in the context usually of a bipolar disorder, and depression. So these are not uncommon disorders. Bipolar disorder is present in about 1 to 2% of the population in the UK. There's a strongly genetic component to it, so family history is quite important. Two types of bipolar disorder broadly. There's one where people mainly go high in their mood, and one where people mainly go depressed in their mood. And there's a high association with suicidality and bipolar depression, and that's a common theme with psychotic mental disorders in general. Suicide is a high risk, and you can imagine that if you're experiencing these symptoms a lot, it could be quite distressing and can lower your thresholds to harm yourself. Depression, you may notice evidence of low mood, poor eye contact. People might be tearful, expressing thoughts of self-harm or suicide. You might not get a sense of much emotional interaction from them. And they often may be underweight because they don't eat very much. Their appetite is reduced. They have biological symptoms such as loss of weight. And they can often be reduced in their volume, reduced in their movements, reduced in their speech. So the opposite of that, in a way, is mania. This is where the mood goes very, very high, but it can also not just be associated with elated mood and happiness, or sort of excessive happiness. It can be associated also with agitation and anger and very impulsive behavior. Similarly, these mood flavors can have psychotic elements to them, which are kind of usually in keeping with the prevailing mood. So somebody who is very, very depressed to the point that they're psychotic may well believe that the world is ending and that their body is rotting, and that that there's no future, and that that these delusional beliefs are so intense that they may decide that they want to kill themselves, and it's not uncommon in cases of filicide, where mothers may kill their child to have a psychotic element to a severe depressive episode. Similarly, in mania, if people have grandiose beliefs and they're very high, they think they've got special powers, they may take slight to people saying or doing certain things against them, and they may also be disinhibited, wearing inappropriate clothing, behaving in an inappropriate manner, including sexually. And so this is obviously the extremes of the presentation as well, that we can see interfacing with the criminal justice system. Treatment for these disorders is with antidepressants or mood stabilizers, sometimes antipsychotics, and on occasion electroconvulsive therapy. And as I said, the types of offences may be varied, but mania and impulsive violence have associations, and impulsive sexual disinhibition and offending. And obviously, I've talked about filicide. So the medical legal implications of that are again through the criminal justice system. And Mental Health Act disposals may be under consideration for these types of disorders as well. Next slide, please. So the developmental disorders as well, these are the disorders which include things such as learning disabilities, autism spectrum disorders, and more recently becoming much more clearly issue in the prison population of young men, attention deficit and hyperactivity disorders. They're relatively common in forensic populations, and up to 30% of prisoners might have undiagnosed learning disabilities. Similarly, associations with sexual offences and simple violence. And there may be difficulties understanding words that can be picked up during interviews and meetings with people with learning disabilities. But you have to be careful that they don't do something called a response set, which is they say yes, 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 or no, 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 and just say the same yes or no response, which can give the impression that they actually understand what you're asking them. Whereas in fact, if you create a question that might trick them out, they may well say yes again, which gives you a bit of a sense that they're not actually understanding the questions that they're being asked, but they're just saying yes or no as a way to move forward. That's called response set, and you do see that with people with learning disabilities, and it obviously has quite significant issues in medical legal context. Similarly, such individuals with these sorts of problems can have issues of suggestibility, which is along the same sort of spectrum. Autism spectrum disorders are quite complex disorders. Again, they're not uncommon. They're much more common in males, 3-to-1 ratio, really, and they're disorders that are describing problems with social skills and interactions, and what's called the theory of mind, so that the difficulties in understanding how other people might be perceiving them or perceiving the world, difficulties in understanding how other people might be thinking about what's happening to them. It's not uncommon that there can be stressful outbursts which could include violence and aggression, and in people with higher functioning autism, so people who don't have a learning disability, we have a real problem, I think, in mental health services as to how we how we deal with these people, really, from both a non-forensic and a forensic perspective. There's a bit of a gap in services. And attention deficit and hyperactivity disorder, ADHD, is becoming increasingly recognised as having quite a significant impact within offending behaviour. So these are the often young men who may have had an ADHD diagnosis in childhood that may have persisted, but become evident through their impulsive behaviour. They're getting into trouble as kids, often being labelled as problem children, having conduct difficulties, and carrying out offences, often not necessarily serious offences, but impulsive offences, which bring them into contact with the criminal justice system. And there's certainly been projects and research in young offenders institutes in London, in YOI ISIS. Professor Philip Asherson has done studies looking at the prevalence of ADHD in these young men, and it can be very high. And there can, I mean, it's not to say that treatment with the medications is a silver bullet, but it's obviously quite a significant factor in reducing impulsivity, where this can be a factor in offences. Next slide, please, Marie. So I've put a slide about personality disorder. Now, personality disorder is really quite a complex and quite a vast area, really, but personality disorder is really talking about the way that certain people have developed their abilities to interact and cope with stress in the world in a way that isn't helpful to them and isn't helpful to others, and in fact causes harm to them and to others, which can often lead them into circumstances with the criminal justice system. There's lots of different terms of personality disorder, but what we tend to see in the criminal justice system is people in what we call the cluster B types of personality disorder. These are people who have emotional instability, traits of narcissism. They can have dissocial type behaviors, disregard for authority, tendency to act out in violent or impulsive or self-harming kinds of ways. They're at a high risk of harming themselves, a lot of these people. And the cluster B type disorders are more difficult to treat. They ultimately require a more prolonged period of psychological treatments in conjunction with dealing with social crises that happen. And within the offender pathways within the UK, there's increasingly focus to try and have a strategic pathway for people who have personality disorders within prisons and also within the probation service. So there's something called the integrated care services, which are being set up across London at the moment, whereby people who have a personality disorder diagnosis or are suspected of having one and are under probation in the community can be referred to integrated care services in order that they could engage with community psychological therapists with a sort of an offence focused aspect. So that's obviously quite important consideration for people who may get community disposals. Next slide, please. So talking about the dementias, now I'm mainly an adult psychiatrist, but we do see in the courts dementias that are established dementias, people with cognitive problems, which is their ability of the brain to process and use information. Commonly, memory loss can be a cardinal sign of this, but there can be lots of other signs of their difficulties in processing information. There are tests that can be done, looking at various pictures and words and ability to remember and name things. So there's a number of tests that can be done to sort of screen for these and to pick these sorts of things up. And if they are identified for the first time in criminal justice context, it's quite sensible to involve an older adult psychiatrist or a neuropsychiatrist to characterize them more fully. One of the things that's challenging is the picture can fluctuate, and they may appear well at times, and stress and lack of sleep and various other sorts of things and whether they've got an infection of some sort can really sort of cause fluctuation in their mental state, and sometimes they can appear quite well. So one of the cases that I was involved in, which was an appeal case, was the case of Mark Antonio, which was in 2016, and that was at the High Court as part of a broad number of appeals. And I'd seen Mr. Mark Antonio had a clearly established diagnosis of a dementia, and wasn't fit to plead in the case that I was involved in. But there'd been a previous case some years ago which was being appealed, and it hadn't been regarded by the solicitor that they couldn't take instructions or didn't note dementia in the case. Ultimately, the earlier verdict of him being fit to plead wasn't overturned, but it goes to show that actually people with dementia can appear to function normally, and can appear to, and indeed can function normally, but it may be a fluctuating picture, and it's important to bear that in mind, particularly in criminal proceedings, that their capacity may fluctuate at different times and different circumstances. Okay, next slide, please. So substance use is a very important aspect that is very commonly available, very commonly seen in offending behaviour. So technically, this is a mental disorder within the ICD-10, but it's often not treated as one by the courts because of the voluntary/involuntary aspect of it. Addiction as a disorder has a lot of genetic and biological components to it, as well as psychological aspects to it. And acute intoxication does alter mental state. And certain drugs, such as amphetamines, cocaine, stimulants in particular, can contribute to psychosis, cannabis being another one, particularly in people who are vulnerable to it. Now, it's important to recognize that not all people who use these substances do become psychotic, suggesting that there's a vulnerability there and may well be indicative of an underlying mental disorder. So it's also of relevance that there is treatment for a number of these disorders, particularly substitution treatment for people who have heroin addiction, opiate addiction, and for alcohol there's available detoxes, and there's also available anti-craving and medications to reduce relapse, which are available. And so I think when there's a primary addiction element to a case, it's important to bear in mind that there are disposals available to try and help address these. Next slide, please. So I'm conscious that in the audience there's a number of people who I'm sure are very experienced, and I don't want to teach you to suck eggs, as Marie says, but I just thought it might be helpful to give some suggestions of questions that might be helpful to think about if you're wondering whether a mental health problem might be relevant in your client in front of you. Now, obviously, Marie mentioned the issue of insight, which is that some people don't believe that they have a mental health problem or don't recognize they have a mental health problem, and that can be a manifestation of the illness itself. But there are things that I think you can ask which might give you a bit of a heads up that mental health factors might be an issue in your particular case. So just directly asking whether people have mental health problems, whether they've ever seen a GP or psychiatrist about their mental health, whether they're under a team, whether they've ever been admitted to hospital, whether there's a family history of mental health problems. There's things like bipolar and schizophrenia, and mood disorders as well, to have family histories being quite significant at times. You can ask more, less perhaps using terminology of mental health that might be more acceptable, such as asking people if they ever have problems with their mood or their emotions. And you can ask things about whether people have ever harmed themselves or whether they feel suicidal. And I think it's a common misconception that asking that question will either increase their risk of doing it, or that it might be a difficult thing to ask. It's not an easy thing to ask, but I think people are often relieved if you ask them about it. And they say to you, yes, I do actually feel like that. So, that indicates that somebody may have a mental health problem that needs quite imminent addressing in some way. Medications for mental health are important. So it's important to ask people if they have medications, not just because of the effects of the medications immediately, but also it might indicate if they have mental health problems, such as psychosis and such as mood problems, which if they've not been taking their medication could be relevant. And you can ask people about their memory, whether they get confused, whether they have problems with their reading or their writing, whether they use substances and alcohol, and if they do that to change the way they feel, and to get a sense of how much they are, to get a sense of whether this is a problem. Next slide, please, Marie. So I just wanted to mention court liaison and diversion. I did mention it earlier just as part of the Bradley changes that happened over the last 10 years. Now, there's pretty much every magistrates court and police station now have some degree of a diversion team in them. They are a source of collateral information, as they can have access to medical records and obtain information from NHS records about people's contact with mental health services. And they can be useful as a point of contact if you have an issue about mental health problems in your particular client's case, then it can be good to have a discussion with them to see if they can perhaps list the case for a day when their psychiatrist might be there to do a sort of a brief assessment of fitness to plead, or to raise mental health issues in the sentencing context. I think there's variable quality. It depends on the day, it depends on the person, and you may well get a perspective, not necessarily the breadth of opinion. So it doesn't sort of completely absolve the role for there to need to be expert opinion or other views, but it's certainly quite important in the live interface between mental disorders and the court. And certainly when you have mental health sentences being considered, the liaison diversion team can be really helpful in identifying the relevant services, the relevant teams, and smoothing all of the pathways. Next slide, please. So the mental health disposals, I think many people will be aware of the hospital disposals, section 37, 3741s, and other variations of that. What I wanted to just really say about these is that usually they require there to be the mental health factor to be raised quite clearly in the case, and for people's mental illness to be of a nature and a degree, and their risks to be warranting inpatient admission. It's very rare that they'll be imposed, and it's usually a bit of an exercise in diplomacy. And I often see situations where I get asked to provide a second report to put someone on a section 37. I can do that, but it's probably not going to be helpful, because you do need 2 reports, but you really need one of those reports to be from the service where they're going to be admitted, unless they're already inside somewhere and your expert is in conversation with the consultant for that inpatient service. I think there's often a conflict between the medical perspective and the legal perspective, which can be about the restriction of the outcome. And I think disposal to hospital can be seen as a restrictive outcome when you may be considering suspended sentence or other things like that, and there can be a conflict there between what we think is in someone's best interest as doctors and what may be felt to be in someone's best interest from the point of view of their liberty. So that's a tension that needs to be negotiated and considered. And just finally, to the last slide, I wanted to just give you a little bit of data about how much these sorts of disposals are used. In 2010, there were 540 hospital orders. 2019, about half of that. Section 3741, similarly, 2010, 360, 2019, 25. Hybrid orders have gone up in their use, but they're still low numbers. Why is that the case? I mean, there's lots of possible reasons why that's the case. It may be that people are being diverted from criminal justice systems, the more serious cases, early, that they're ending up in hospital early, that the liaison diversion practitioners are able to raise the issues of mental disorder, so it's not getting so far down the line that the hospital orders are being used. I think that one of the things that could be considered as an option, and should be considered as an option, but aren't used as much as they could be, are the community orders. And mental health treatment requirements are real options as a community alternative, and are mentioned quite specifically in the sentencing guidelines, particularly when people aren't necessarily at the threshold of being admitted to hospital, and where there's been a degree of contribution of mental disorder, but not absolutely so, to the offending behaviour. Drug rehabilitation requirements and alcohol treatment requirements have been used much more so, although there's still a lot of potential for those to be used. It may well be that because they are more often interfacing with probation, whereas the mental health treatment requirement requires a responsible team to be identified. So, and finally, as an example I can give you of where considering the mental health factors in sentencing did lead to a mental health treatment requirement, but within a breadth of range. A judge was considering for an arson case that I was involved in for a man with a brain injury and a personality disorder probably existing before, but contributed to by his brain injury. He was considering a whole range of sentences, all the way from a life sentence, and was making a finding of dangerousness for this man for a reckless arson, down to a mental health treatment requirement and suspended sentence. And I think on the basis of being able to identify the right package for that patient offender at that time, we were able to present to the court an option that it could consider in conjunction with the community team to both manage the risks and to allow an opportunity for treatment and rehabilitation to occur in the context of a treatment requirement, as opposed to a life sentence. Although I've got very little doubt that if he doesn't comply with the treatment requirement, he'll be recalled to court and the judge probably will consider a life sentence. But it's certainly provided an option there, which I think is in the spirit of the sentencing guidelines. Thanks very much, Marie. I'm mindful I've spoken for longer than I intended to, so I'll hand back over to you.
No, not at all. It's as ever very interesting. And I think listening to you particularly, although of course I had an idea of what you were going to speak about, it just sort of makes me as a practitioner, I'm sure many of the others on the session this evening, really think about the fact that we almost sometimes become a bit too blasé about these conditions, particularly with young people and ADHD, and there's some elements of real cynicism about those. And this is why I myself think that this guideline is really timely, because it is that back to basics thing I said at the beginning, and it's a good chance for us all to sort of think, well, hang on, there isn't something that needs to be dismissed. We've got to really try and do our best by bringing this to the forefront. And the example you just gave there, Brad, in relation to that particular case where a judge was looking at a whole spectrum, literally from a life sentence down to what ultimately was a properly considered community order, just really goes to show you. And of course, more often, cases where you will need the guideline are going to be those where it's on the cusp. And in particular, paragraph 22 of the guideline is another sort of favourite part of mine, because it's really getting somebody to think about that cusp of custody or community sentences, and often, of course, the interim of a suspended sentence. And it's a really useful thing to think about. And when we're trying to look at where really resources could be best directed in terms of the long-term benefits, both for the offender and, of course, for the community, that there's some really good stuff in there. I think it's really important to pick up on what Brad was saying about the exercise in diplomacy. It is difficult, and of course we're all aware as practitioners from both sides of the profession that of course we'll all have dealt with clients where they are not accepting that there's any form of mental health issue or disorder, and of course that means that there's very little we, if we're defending, can do about that. But of course the system at some point should kick in and appreciate that. And that's sort of a whole other lecture about those difficulties and our own professional codes. But it's also diplomacy, not only with the client, it's also diplomacy for the court, in a way addressing that sort of sceptical approach I just mentioned, for the family, who may not want necessarily to recognise or to feel if mental health issues are being raised, that it's some sort of reflection on them and things that have happened in the past and so on. So it does really need to be handled very carefully. And I think also the important message from this evening is that we have to remember as practitioners that we are not psychiatrists or psychologists, or indeed social workers, or all the other things that on a daily basis we're expected to be by the courts. And it's my husband's favourite saying to me to remind me that I'm not all of these people in one, but he's quite right about it. And I think we sometimes do need to remember that we need the help and the input of experts from sort of the top level with somebody like Brad, but also those practitioners at court who certainly are getting much more user-friendly from my point of view. A good example in a murder trial I've just been doing is that we had real trouble getting the prison health records under some, on the face of it, spurious GDPR reason, even though they concerned our client. And in fact, it was the liaison and diversion practitioner at court that was able to get them for us very easily, had access through to them on their system. And with the appropriate order from the High Court judge, we had them very swiftly. So, you know, people have got to start pulling together and working together, and the resources are more and more there. Just one couple of final points, if I may, but one particular one linking in from what I've said about the exercise in diplomacy, but also being aware of some particular issues, is that in the guideline under section 1, there's a specific reference, and I've put it up on the slide there again. I'm not expecting you to be able to all read it from my screen, not least with the camera view on the side. But this is directing our attention as practitioners to the fact that there's also really important issues in relation to cultural, gender considerations and ethnicity issues in relation to mental health. And in particular, really a reminder for us all that in some sections of the community, there's really still a real stigma about mental health and raising these matters. particularly in a courtroom scenario, particularly when people are conscious about press reporting, about apparent raising of risk just because you're mentioning these things. And it does all need to be handled very carefully and with due consideration. As it says in section 1, in addition to the general concerns about people from particular communities, that female offenders are more likely to have underlying mental health needs, and the impact therefore on females from BAME communities in particular is likely to be higher given the intersection between gender and race. And it goes on to say that refugees and asylum seekers may be more likely to experience mental health problems than the general population. Well, it may be no surprise to any of you to hear that just from your experiences in practice, but it's now written down and it's now something that we can make reference to, that it's not just something that the defence are coming up with in inverted commas. We did bill this lecture as being about advocacy and the guideline. As I've said at the outset, the aim wasn't to try to teach any of you how to use the guideline, because you can all read it for yourselves and know how to use it yourself. The idea of bringing in together Brad's experience and just really taking us all back through what we already know, but in the context of the guideline and the sentencing code, as I mentioned, just really trying to think about how we can best use it. And just to sort of close really, the points that I put on this final slide are to think about how you can use it in your particular case that you might be dealing with. To think about those questions I mentioned at the outset of this evening that are set out at paragraph 15 really is a framework for thinking about if these factors apply to the case you're dealing with, how you might best get information and how you might best then help your client in relation to it. Think about how to make the guideline a central feature of the mitigation alongside, of course, the offence-specific guidelines. But there will be many instances when, in my view, this guideline will trump the offence-specific guideline. And that's really important, particularly when we're back to dealing with those cusp cases. Remind the court of their duties under the guideline, both at the point when you're applying for reports, or asking for an adjournment for reports, and also, of course, particularly at the sentencing hearing. And do remember to think creatively. It's back to the cusp point. It's back to thinking about literally the whole range of sentences available. As Brad mentioned, that really there is more that can be done, and trying to find a way to get mental health treatment requirements as more of a sort of standard approach to be taken by those considering a range of sentences is something that I think will be really improve things for all. Use are a particularly difficult area, and again that would be a whole different lecture in relation to mental health conditions and the impact upon offending, but it's another important thing really just to note. I think, again, from the personal view of my practice, we will see more and more cases, particularly as we continue to be in the pandemic. It struck me that just in the last few months, I've had 3 cases of arson, and probably in my practice over the years, you know, maybe 1 a year, 3 within the last few months, all on the face of it linked to things arising out of the pandemic, exacerbation of either underlying mental health conditions with substance abuse, as Brad mentioned earlier, or new conditions emerging. And I think there will be more ongoing impact in that regard, and that back to that interplay with offending that Brad so helpfully took us through. I think the final thing really is to say what I suppose when I teach advocacy to young practitioners at the inn or in chambers, really something I often say is that a basic rule of advocacy really has to be, in a considered way of course, if you don't ask, you don't get. And really the use of this guideline in a proper way with expert input is a way we can really try and help our clients to get the right sort of treatment and hopefully improve things more generally. Okay, so I'm hoping we're going to maybe have time just for a few minutes to answer some questions. I'm going to stop sharing my screen, and I know Sarah's there to help us, as she always is.
I shall certainly do my best. Now, from the chat that we've got going at the moment, I know that there is one question, or I know that one person has a question, and so I'll just try and unmute. And at this point, if anybody else wants to turn their cameras on, then please feel free to do so now. I think it was a question from Juliana, if hopefully I'm pronouncing that correctly. I think you had 2 questions.
Hello, my name is Juliana. Don't worry, I get it all the time. The first one is Luliana, so it's fine, don't worry, you were close enough. But you can call me Julie, of course, it's fine. I've got plenty of people calling me Julie anyway. So just to give you a little background, I am a student in applied forensic psychology for masters, and my course leader is Dr. Kieran O'Keefe, which you might know. He's the one who proposed that I should attend the webinar, and now I fully understand why. So I have a great passion of psychopathy and dissociative identity disorder. And my question was 2 questions, but I'm try and merge them into one. Whether you've had a case of an individual who had who has dissociative identity disorder and has committed a crime that the other personalities did not know of, if that makes sense.
I think that's one for you, Brad.
I think that's one for me, yeah. Thank you for your question. I haven't had a specific case, no, where that's happened. And I think dissociative DPD, dissociative personality disorder, dissociative identity disorder is very rare and really poorly understood, actually. But I think what that disorder in particular does relate to is the impact of trauma, a very serious impact of trauma, which has often got a thread through all of these disorders. People with mental disorders are far more vulnerable to having had a history of traumatic experiences either in their childhood or in adulthood. And obviously in the cases of in things like PTSD or complex PTSD, which is a sort of more complex disorder where you do get problems with identity and dissociation, that can be relevant. So your specific example, no, I haven't had a case. I'm not familiar with a case where that might have happened. And I think it would probably be quite a challenging one to argue in court, because that would be quite a controversial diagnosis anyway. And you come across issues as to whether people are malingering and things like that, because there's no objective way of telling whether the other possible personalities have got an awareness, if you like. But dissociation does come up in cases as to whether people have dissociated because of traumatic experiences that they've had in the past that get relived in offending behavior. And I can certainly think of cases of GBH and things like that, where people have attacked in a kind of responsive way to a reliving experience of some sort of trigger going on around them. I hope that kind of answers your question.
It does, thank you. And my last one would be if you'd be able to give me an insight of what it's like to have a chat with a psychopath.
Well, that in itself remains a controversial diagnosis as well. In fact, it's not a diagnosis. And certainly some people, if you look in the sentencing guidelines of Professor Taylor, who contributed some of them, would regard it potentially as a pejorative term, but it may represent a group of people who have a very particular constellation of personality traits. There is something that you might have heard of called the psychopathy checklist, which is an investigation which is sort of done on a variety of different domains to look at whether somebody is psychopathic. But it is, again, not without controversy.
I understand. Thank you very much for that.
All right, thank you. Now, we have got another question. It's going to be another one for you, Dr. Hillier. Let me just unmute. Oh, here we go. So this is a question from Simon King. Simon,
yes. Yes, sorry, I just wanted to ask Dr. Hillier if he could give us some guidance as to how we can encourage the probation service to look to mental health treatment requirements as a disposal. It's quite startling to see the statistics there, and they are extremely rare. So I don't know if you could give us some insight as to how we can push them in that direction.
I mean, to be fair to the probation service, it's not just them really, I think, that need to be involved in this. I think mental health services need to kind of up their game really. I think you'll probably find that probation services probably don't feel familiar enough with working with mental health teams because they're so underused, that they probably don't raise them that much. So it's usually when you get an expert involved that starts to say, well, you know, this is the kind of case where a mental health treatment requirement could be part of a community disposal, who can then sort of make the links in the mental health world with community mental health teams to be able to talk to the people who would ultimately be sort of supervising that person under their mental health treatment requirement. And in my experience, when you do it that way, the probation will they'll often look at your pre-sentence or my pre-sentence report where I've said a mental health treatment requirement. And even in this case, this guy who committed the arson I told you about, where I said, you know, a mental health treatment requirement could be considered, the probation officer said, well, I think he's dangerous, but actually I see what Dr. Hillier is saying. So if Dr. Hillier is able to sort of look at how we would navigate the mental health system to get a mental health treatment requirement in place, then that would be something that they would support. So it's often, like I said, again, an exercise in diplomacy. Really, I think trying to get something mental health involved earlier on. But I do think that there is work to be done more broadly about how mental health treatment requirements can be used more widely. And I think it does need more integration with the mental health system, which is happening with the Bradley report and its effects over the last 10 years, but still could be better.
Thank you. Thank you.
Good. Okay. Well, look, thank you all for bearing with us. I know we had just a slightly late start, so we're just about an hour now. So we're really grateful to you all for attending this evening. It just strikes me, just even now on the questions, that there's so many different and interesting areas. We could go on all evening, but I'm sure you will have some other things to do. Can I just give my thanks, first of all, to Sarah for managing this so well at the Zoom and making sure it all works and keeping us on track. And also, of course, my particular thanks to Dr. Hillier, who has given his time to us this evening. And you know, even from my point of view, and I, as I said already, I know what he was going to say. I still find it all very interesting and helpful. So that's it really from us. Thank you again, and hope to see you all in real life at some point soon.